All right. Good afternoon, good morning, good evening, good night, depending on when you're seeing this video. So today we'll be looking. Here's my marker. So today we'll be looking at. So today we'll be looking at acceptance. We are still continuing with acceptance. So today we'll just be looking at two headings. Of course, we are coming to the end of acceptance. After acceptance, we will have to enter consideration. So in order to understand contracts, remember that what we are explaining is that we have elements of contract. We have offer, acceptance, consideration, intention to create legal obligation, and capacity. And what we'll be doing, everything we have been doing is still under the elements of contract. And so we must have to understand these elements, because these elements are the building blocks that make up contract. So we are in acceptance. We've looked at the definition of acceptance. We've looked at invalid forms of acceptance. Now, let us look at moment of acceptance. When is it that when an acceptance is done? When can you say that acceptance has been done? When can you say that, okay, since acceptance is a vital part of contract, yeah, if all the elements are vital parts, yeah. So, but then you need to know when acceptance is being done. Since acceptance is extremely important, that it must be done. Remember when we were talking about counter offer? We said that counter offer, no matter how many times you have offered, even cross offer, cannot be seen as an acceptance, because it is not an acceptance, and we need an acceptance for a contract to be a contract. And so it is very important that we know when exactly does acceptance take place. Because if you don't know when the acceptance has taken place, you wouldn't know when liabilities has arisen as a result of a contract being in place. So we must first know when does acceptance take place, so that we will now know that, okay, when we now get the particular time acceptance takes place, we now know that this is when the contract has started, so that we will not be confused on, okay, whether or not there's a contract and stuff. So the moment of acceptance is when the offeror, that is, the offeror is the person that made the offer, has been told or informed about the acceptance. So if you have accepted something, you have accepted an offer, and inside your mind you have kept it to yourself. Somebody has made an offer and you said, okay, I will buy it. Inside your mind, you have agreed with yourself, but you've not let the other person know that, I will buy this thing that you have offered to me. And you have accepted inside your mind, you have agreed with yourself. Then later, you now found out that the person that made the offer to you, because he has not heard from you, sold the same thing that he said he wants to sell to you, that he has made an offer to you for. Can you now come and say that you are suing the person, the offeror, because he sold something, even though you must have agreed with yourself that you will buy it? Maybe you are trying to bring the money together in order to buy it, and you now see that he has sold the goods. The question the court will ask is that, did you communicate that your acceptance, or was that your acceptance subjective or inside you? The moment of acceptance is when the particular offeror that has made that offer is being informed of your acceptance by the offeree. Of course, you are supposed to communicate your acceptance to the offeror. Even though, like we noticed in the last class, that acceptance can come in different expressions. That is according to Toby JCA in the case of Orient Bank against Bilante. Now we have acceptance by words, by conduct. Forgive my handwriting, please. Then by document exchange. Now, of course, we know that when we talk about communicating our acceptance to the offeror, all of us, what we would think about is by words. Because when you are talking, when you want to accept by words, you must make it very clear to the offeror that, see, I have accepted your offer. By conduct is also communicating your acceptance with your actions. So the offeror says, please bring me 2 tubers of yam. I will give you 200,000. That is so costly. 2 tubers of yam for 100,000. Bring 2 tubers of yam. I'll give you 2,000. Then you now supply the 2 tubers of yam. That is acceptance by conduct. You have communicated your acceptance. Now, if they say bring something, or if they make an offer to you, and you know within yourself that you will do that thing, it is better you communicate your acceptance. That is, if the circumstances present itself, that you must have to communicate your acceptance, because that is where the acceptance has taken place. Not when you have accepted in your heart, but when you have communicated your acceptance to the offerer. That is the moment of acceptance. Now, mode of acceptance. Sometimes you will see a contract that would say a particular mode they would want you to respond to them. They would want you to accept the offer for. So when you see an offer that has a prescribed mode, in order to say, follow this mode if you want to accept. We will accept email, follow only by email, or only by post, or only by any other thing. Mode of acceptance, when prescribed, you are expected to follow that prescribed mode of acceptance. However, if you now follow a mode of acceptance that is ordinarily faster than the prescribed mode of the acceptance as written in the offer or as provided for in the offer, nothing stops you from doing that. Nothing will remove your liability. I will take it again. They have provided a mode for acceptance. Use this mode to communicate your acceptance to us. But then you now use a mode that ordinarily, to a reasonable man, is faster than that mode that was prescribed for you to follow. The law allows it. You will not be held responsible for not following a particular mode of acceptance, provided that that mode of acceptance you followed is faster than the mode that was prescribed. So if you follow a slower mode of acceptance other than the mode of acceptance that was already prescribed for you, then nothing actually stops you, because if your acceptance is slow and reaches and the offer is still open, then you are okay. But the problem now arises when your slow mode of acceptance has arrived to the offeror, but the offer is no longer open. Maybe another person has accepted, he or she has offered to another person. So the law now says that because you have followed the slower mode than the mode prescribed for the acceptance, it is your business. The law will not subject the offeror to open an offer for you, to leave the offer open for you when you have decided to follow a slower mode than the mode that was prescribed for that. But if any mode is not prescribed, you can follow any mode for your acceptance. But if a mode is prescribed, you're expected to follow that mode that is being prescribed, unless you have a faster way to communicate your acceptance. I hope you understand that. Now, let us go into acceptance by post. Now, remember, let us go back to moment of acceptance a little bit. We said that moment of acceptance is only when the acceptance is being communicated to the offeror by the offeree. However, there is an exception, acceptance by post. What is acceptance by post? Or we say is the rule in Adams against versus Lindsell. This is a very important locus classicus. Locus classicus is authority, that a principle is based on, is hinged on. Acceptance by post, or the rule in Adams against Lindsell. So most of the times your lecturers can be very funny. Your lecturers can say, explain or substantiate the efficacy of the rule in Adams and Lindsell. They will not tell you that it's acceptance by post. They just say substantiate the efficacy of the rule in Adams and Lindsell and analyze whether it is morally justifiable. Aye, I suppose they set law questions. So, what is acceptance by post? And how is it now an exception to the moment of acceptance that we just discussed? Moment of acceptance, the acceptance must be communicated and the acceptance must have reached the offeror that made the offer before the acceptance is valid. But acceptance by post is saying that if you take that your acceptance in form of a letter and you post it in the post office, you post it, even though it has not reached the offeror, that posting alone is enough acceptance. So acceptance by post is that acceptance is complete when you post your acceptance, even though it has not reached the offeror. So acceptance by post, the rule in Adams and Lindsell is saying that your acceptance is now valid and complete when you post the letter of acceptance. But even though it has not reached, at the point of posting, that is when you have accepted. So you see that it is so much, it has so much, what do you call it? Controversy. It is controversial. But there are exceptions. There are exceptions. So let us the rule in Adams and Lindsell is so absurd. It's somehow. I don't even know why that rule is still followed till now. Of course, you know that we are not, in the era of posting letters and all that. So we are now in the world of digital, both WhatsApp, email, and all that. That if you even post your letter by email now, it will get immediately. So you cannot really say that. I don't think it should even apply to email because email. Let me not go into that place because there have been not much jurisprudential, write-ups or articles on that. So let us not go into that. So let us just focus on the scheme so that we'll pass our exams. Now, exceptions to the rule in Adams and Lindsell, that's exception to acceptance by post. Number one, where the terms of an offer indicates whether expressly or implicitly. So you don't just say that I did not indicate in the face of the motion in I say motion paper. Sorry. Don't just say because it did not indicate on the face of the offer that it did not indicate that it was read. So where the terms of an offer indicates that the acceptance must reach the offeror. So if the offeror in making the offer says that CO, in order for this acceptance to be complete, I must be informed and the acceptance must reach me. So if there is some kind of indication, whether expressly or implied, then acceptance by post will not apply. So that when you now accept by posting, and you're not claiming that the law in Adams and Lindsell says, if you post, the acceptance is complete. This particular one will now say that there is a term in that offer that says that acceptance must reach the offeror, which you accepted. And if you claim you accepted, it means that acceptance must, in fact, reach the offeror. Now, another exception, where application of the rule will produce manifest absurdity. I don't even think there is any other place. Like the rule itself, for me, in my opinion, generally the rule will always produce manifest absurdity to me. But it is an exception here. So it's now left for you to prove. It is now left for you to hire a good lawyer to prove that CO, the acceptance was done by post. But before it would have reached me, I had already sold. And now the offeree is trying to sue me for selling off the properties which, according to him, he accepted before I sold off. So he accepted today, that is, he posted today. I sold off tomorrow because the letter has not reached to me. So is it not causing me manifest absurdity and injustice? So it is now for you to prove how it costs you manifest absurdity. So it is an exception. So if you're able to prove that the rule in Adams and Lindsell, that is the acceptance by post, costs you manifest absurdity, it will not apply to your case, which is To me, I think it's a very absurd rule that will produce manifest absurdity anytime and every time. Where the letter of acceptance was wrongly addressed or inadequately stamped, and where the letter was not properly posted. So this one is now your own fault as the poster. So when you wrongly post it, maybe to a wrong address, or the post office people did not really do the necessary admin duties that they're supposed to do for the letter to reach when or where it's supposed to reach, then the rule will not apply. So that is that about acceptance by post. There are other many things. There are many things about acceptance, but we cannot be going into it. Of course, you can read that one yourself. This, my YouTube class, is just to teach you so that it will not sound new when your lecturers are talking to you about it. You can also use it as an explanatory tool for you that when you read, you can watch this video in order to understand well what you have read, or you can read, then watch this video for the explanation. So it goes either way. So if you're in 200 level, or you're about to enter 200 level, or you're about to do law of contract, no matter the course you're doing, this is the channel for you. Not just law of contract, any other law, because I'll be teaching other laws across other courses. So that is that about acceptance. Please, next time we will go into consideration. 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 It is also big. So we will cut it just like we've been cutting acceptance. And thank you very much for watching. Please like, subscribe, and share. Peace.